Welcome to this explainer. If you're an insolvency professional, a banker, a commercial law student, or just someone who closely follows how we handle corporate distress here in India, you are in the exact right place. Today, we're doing a deep dive. We're charting the evolution from our foundational CIRP framework to the brand new CIIRP introduced in the 2026 IBC amendments. Now, just before we get going, please take a quick look at the mandatory disclaimer on your screen. Just a reminder that this explainer is strictly for educational and general awareness purposes, all right? It doesn't constitute legal or professional advice. Always check the latest statutory provisions for your specific cases. All right, here is our quick roadmap for today. We'll start by revisiting the original CIRP, look at why it needed an evolution, introduce the new CIRP, do a direct side-by-side comparison, and finally, wrap up with the real-world impact on stakeholders. Let's get right to it. So, kicking things off with Section 1, understanding the original CIRP. Let's make sure we're all on the exact same page regarding the 2016 framework. Ever since the IBC rolled out back in 2016, the Corporate Insolvency Resolution Process, or CIRP, has absolutely been the bedrock of handling corporate distress in India. Before this, let's be honest, recovery battles were scattered and they took forever. CIRP really changed the game. It stepped in as a structured shield. The main goal here isn't just to chop up the company and liquidate it immediately. No, it's about rescuing the defaulting debtor as a going concern, saving that underlying business value and balancing everyone's interests.
And the way it works is a very structured journey. It kicks off with a filing and admission by the NCLT. The moment that happens, boom, a protective moratorium kicks in. That gives the company crucial breathing room from other lawsuits, and an interim resolution professional takes the wheel. From there, claims are invited, the Committee of Creditors, the COC, is formed, and it all leads to either the approval of a viable resolution plan or, if things just don't work out, liquidation.
Now, what's really crucial here is how CIRP is actually governed. Anchored in Section 7, 9, or 10 of the Code, it empowers financial creditors, operational creditors, or even the corporate debtor itself to hit the start button. It is strictly time-bound, we're talking a target of 330 days, and tightly supervised by the NCLT. But remember the real drivers here? It's the creditors. The ultimate commercial calls are all made by the COC. Moving on to Section 2, the need for evolution. We've got our baseline, so why exactly did the legislative landscape need to shift gears? It brings up a pretty massive question, right? If CIRP was successfully saving viable businesses and vastly improving recovery rates compared to the old regimes, why on earth did Parliament push through a major amendment in 2026? Well, the reality on the ground was getting a bit tricky. We started seeing some serious bottlenecks emerge. Prolonged litigation and procedural hurdles meant massive delays in just getting the process started and finished. And because of these delays, the interventions were happening way too late. By the time creditors finally got the company before the NCLT, the actual enterprise value had severely eroded. So we desperately needed a more agile, flexible solution that could step in much earlier, without ditching that core creditor-driven philosophy.
Which brings us to Section 3, introducing the new CIRP. Let's take a look at the actual framework designed to clear those exact bottlenecks.
All right, enter the 2026 IBC amendment, formally bringing us the Creditor-Initiated Insolvency Resolution Process, or CIIRP. This sits in a brand new dedicated chapter 4A, covering sections 58A to 58K. And make no mistake, this is explicitly designed as an early intervention mechanism. It gives us a specialized alternative track tailored for a much faster, highly flexible resolution in suitable cases. Now, I really want you to visualize the IBC as a toolkit. Actually, that is the best way to conceptualize these 2026 amendments. CIRP is not throwing out our old 2016 tools. Definitely not. Instead, it's handing eligible creditors a brand new, highly specialized tool to pull out exactly when a distressed situation demands incredible speed and early action. The whole legislative intent here is crystal clear. The goal? Much faster NCLT admission. By jumping in earlier, creditors can actually stop the bleeding of enterprise value. It's all about ramping up efficiency and flexibility. Ultimately, this strengthens our whole creditor-driven model because you're catching the falling knife before it hits the floor, preserving maximum value of the corporate debtor before it's too late. Let's jump into Section 4, CIRP versus CIIRP compared. Now that we know what both of these concepts are, let's map out their statutory differences side by side. Okay, if you really want to master this evolution, lock these statutory differences into your memory. Look at the legal basis. CIRP is our classic, relying on sections 6 through 32A of the original 2016 code. CIIRP, that operates under the new Chapter 4A from 2026. For initiation, CIRP uses the standard sections 7, 9, or 10. CIIRP, however, is triggered specifically by eligible creditors under the new statutory conditions. But notice what stays exactly the same: the adjudicating authority. The NCLT is still the boss, overseeing both tracks. Philosophically, it's a fascinating split. CIRP is your comprehensive, time-tested default route. It's got nearly a decade of rich jurisprudence, Supreme Court rulings, the whole shebang backing it up. CIIRP, on the other hand, represents a newer, highly specialized, fast-tracked alternative. Sure, it doesn't have 10 years of historical case law yet, but it gives you that much-needed agility when the standard default process is just going to be too slow.
So, naturally, this leads to a massive misconception that we need to clear up right now. When a big amendment like this drops, everyone immediately asks, does the arrival of CIRP mean the end of the traditional CIRP framework?
The answer is a loud and definitive no. Absolutely not. These two mechanisms are built to seamlessly coexist in parallel. It's all about expanding options. Depending on the exact facts of the distress, like how early you caught the default, the type of creditors involved, whether the business can actually bounce back, stakeholders can now sit down and strategically pick the absolute best, most effective route. Finally, we arrive at Section 5, Impact on Key Stakeholders. Let's see what this legislative evolution actually means in the real world. Whether you are a banker staring at a stressed account or a corporate borrower trying to navigate rough waters, the impact here is profoundly positive. Financial creditors finally have a legitimate mechanism to intervene early, which directly translates to much better recovery rates. And for the corporate debtors, getting restructured earlier massively boosts the odds of actually saving the company. That means protecting employee jobs and keeping that supply chain moving. Now, if you're an insolvency practitioner or a law student, this evolution demands adaptability. You literally have to master a dual framework now. Professionals are going to be the crucial bridge in making CIRP work smoothly. You'll need to keep a hawk's eye on the evolving IBBI regulations and the fresh NCLT rulings to make sure these tools are used to maximize value and absolutely avoid any misuse like forum shopping.
And that brings us to the end of today's explainer. But before we wrap up, I want to leave you with a final, provocative thought to really chew on. As this agile, fast-tracked CIRP mechanism takes root right alongside our trusted CIRP framework, how significantly will this elevate India's global standing in resolving corporate debt? Could this dual framework literally be the catalyst that makes Indian corporate rescues the most efficient in the entire world? Thank you so much for joining me today. Keep studying those regulations and keep questioning the evolution of our economic laws.